Good afternoon, everyone. Welcome to another special edition of Crime in the Courtroom. John Collins with you today, as always, to have what I am confident is going to be a memorable and stimulating examination of the use of forensic evidence in our society's pursuit of fair and effective justice, not only on behalf of victims of crime and their families, and of course, all of society that are impacted by crime, but also on behalf of defendants who are entitled by the Constitution of the United States to due process when being formally accused of crimes and facing punishment for those crimes. And to the extent that forensic or scientific evidence is used to prove guilt, that's a rather big deal and a huge responsibility. And because it's such a serious responsibility, it requires the serious efforts of serious people that understand just how serious it is. Today is Monday, the 7th day of July, 2025, and I hope everyone enjoyed a fun and restful Independence Day. My guess is that many of you took the entire week off last week, and if you did, I hope it was refreshing and reinvigorating, especially for the many of you out there who make considerable sacrifices in our lives and in your lives and careers in a way that allows us to have a criminal justice system in the first place. Today is our 95th episode. And if you joined us for our 94th episode a couple of weeks ago, which was also an off-schedule, it was an off-schedule special edition, you will recall that we focused on a ruling by the Oregon Court of Appeals in State versus Adams, in which the appellate court reversed the original conviction and sent the case back to trial. The basis of the reversal, as you may remember, was the appellate court's determination that the trial court erred in allowing the testimony of a firearm and toolmark witness who testified that some fired cartridge cases recovered by police at the scene of the shooting were, in fact, fired in a firearm that belonged to the defendant or was somehow in the defendant's possession or control. So this was, as we call it, a firearm identification based on the comparison of the evidence cartridge cases with test-fired cartridge cases produced in the laboratory. And so in episode 94, we covered a lot of different and interesting topics associated with the Oregon ruling, including the underlying scientific foundations of what in forensic science are called the pattern identification disciplines, which most commonly include the comparison of firearms and firearm-related evidence, tool marks, latent fingerprints, footwear impressions, tire impressions, handwriting, and so forth. It also includes, from time to time, forensic odontology, a practice that one of our listeners reminded me that I failed to mention in episode 94, which is the comparison of bite marks to casts that are taken from the teeth of persons of interest, which is probably the most heavily criticized of these practices. And as we discussed in episode 94, all of these forensic practices exist to leverage the evidentiary force of stochastic patterns. Stochastics is the scientific and mathematical study of random phenomena. For my purposes today, I'm going to focus on firearm identification specifically, or firearm and toolmark identification specifically, because it was this category of forensic evidence that was addressed in the Oregon appellate ruling. But I do need to point out that the principles and problems that I'm going to share with you today are almost indistinguishable from other forensic categories I mentioned a moment ago. So please keep that in mind as we go through what I hope will be some very useful and interesting information regarding the admissibility of forensic evidence in criminal cases. Before we get to that, as always, I want to extend my sincere thanks to our great friends and colleagues at Promega, based in Madison, Wisconsin, host of the International Symposium on Human Identification, the largest conference in existence dedicated to the practice, challenges, and opportunities of forensic DNA testing. For over 45 years, Promega has been helping scientists find the answers. Going beyond a focus on products, at Promega, we bring a network of diverse ideas and solutions to drive better results, not only for our criminal justice system, but to protect and preserve our quality of life through the practice of life science. Promega is the team that turns questions into discoveries. Learn more at promega.com. And for information about our upcoming symposium later this year, please visit issuenews.com. That's ISHINEWS.com. For this particular episode, I want to make sure that I emphasize that these are my opinions based on my own direct experience, research, and understanding of the facts. I'm going to do my very best to be fair and accurate in the matters that we're going to tackle today because they are very serious. And I should also disclose, perhaps in the interest of transparency, that I am vulnerable to having some emotional reactions to these issues because I was trained and I practiced for over 15 years as a firearm and toolmark examiner. It is not only a forensic enterprise that I enjoyed, but also one that I respect and revere because I know exactly how much clarity and stability it has brought to hundreds of thousands of criminal investigations and adjudications over the last 125 years or more. And I very much appreciate the hard work and commitment of the community of forensic practitioners that specialize in this area. They do good work and they care a lot about being accurate and giving a voice to these firearms and bullets and cartridge cases that cannot speak for themselves. And as I said in episode 94, they have a lot to be proud of as a community and absolutely nothing to be ashamed of. But please understand that my tone today is going to be quite direct, and I want to make sure that it's understood that these are my opinions and should not be construed in any way as representing the opinions or official positions of our sponsor, collaborators, or any other organization with which I am affiliated. Sponsorship of this podcast and working with me in a coaching or training engagement is not an endorsement of my opinions. About a week ago, I spent a few hours reading and rereading the appellate ruling in State versus Adams. And the effort that I made, I think, was heavily inspired by the feedback I received and the interest that so many of you took in that last episode. Over the years, I have testified in Daubert hearings, evidentiary hearings, death penalty cases. I've written 4 books, 5 if you include the second edition of 50 Situations. I've published peer-reviewed research on these topics. I've been called to the stand by the prosecution and by the defense. And I've spent a lot of time reading transcripts of expert testimony in a variety of forensic disciplines. I've taught and continue to teach hundreds of forensic practitioners in the art of giving reliable, trustworthy expert testimony. And throughout this professional journey of mine, I've had to read a considerable number of court rulings involving different kinds of forensic evidence and even non-forensic expert testimony. That being said, the State versus Adams ruling by the Oregon Court of Appeals may be the most abusive, lazy, overreaching, and irresponsible judicial ruling that I've ever had the displeasure of reading. It is beyond ridiculous in its easily refuted assertions, its misunderstandings and mischaracterizations of science, its distortion of the 1993 Daubert ruling, and it also makes the grave mistake of granting what seems to be a complete and total scientific deference to 2 famous reports that don't even come close to deserving it. And that was the 2009 National Research Council report on strengthening forensic science in the United States, as well as the 2016 report by the President's Council of Advisors on Science and Technology, also known as PCAST. What I would like to do is to quickly explain why the ruling in Oregon is so bad and deserving of the historical trash heap, as they say. But I want to draw from my own experience to explain what is actually happening in these kinds of cases and beyond Oregon, the threat being posed by what I would describe as an irresponsible band of courtroom science activists who parade themselves as experts in the validity or invalidity of firearm identification. They are professional commentators. They have no experience in actual casework practice. I'm not going to call them out by name as much as I would like to, but I'm going to explain what they're doing, why they're doing it, and I'm going to provide some specific strategies that can be used to make sure that reliable forensic evidence is allowed to have the maximum positive influence on any criminal proceeding in the United States. If you want to learn more about this and these other issues that we will discuss, I will include a link to my textbook, Crime Lab Report, in which I've addressed much of the activism that I'll be talking about today. With regards to the appellate ruling in State versus Adams and the court's rejection of firearm identification as a valid forensic methodology, we actually have to embrace that there was absolutely nothing wrong with the defendant arguing that the firearm evidence should have been omitted at trial. And there was certainly nothing wrong with the appellate court considering arguments about whether or not the prosecution's firearm testimony met the requirements of the relevant rules of evidence. That's all fine and good. If the defendant has a credible reason to believe that the testimony should be ruled inadmissible, then he or she has a right to make that claim. Of course, the appellate court may or may not choose to consider it, but the claim can be made, and the appellate court may elect to hear the case, as they did in Adams. The argument made by Adams was that the identification of the fired cartridge cases as having been fired in the defendant's gun did not meet evidentiary requirements, and the appellate court elected to hear those arguments. No problem. That is due process. It's sometimes an ugly process, but it's how the system works, and certainly professional expert witnesses have to appreciate the value and importance of this part of the process in preventing the unjust or erroneous conviction of innocent people. Now, where the appellate court abused its authority was in becoming distracted from its responsibilities to the case itself and to the evidence in that particular case. Instead, what it did was it took upon itself, as if it had the expertise and authority to do so, to conduct a full sweeping critique of the scientific and practical underpinnings of the practice of firearm identification. In other words, it wasn't just about Adams and the evidence in the Adams trial. Instead, the appellate court put the entire practice of firearm comparison and identification on trial and issued a conviction, if you will, of these methodologies as being invalid. In doing so, the appellate court revealed itself as an activist group by definition. It revealed its profound misunderstanding of the Daubert ruling. It revealed its profound misunderstanding of science. More importantly, it largely dismissed and ignored the scientific relevance of a century's worth of practice, research, scrutiny, and success in the comparison and identification of firearm evidence. And it blindly accepted what it clearly regarded as the validity and legitimacy of those two governmental reports I mentioned earlier, never once subjecting those reports to the same kind of scrutiny or intellectual inquiry that it claims is lacking in the practice of firearm and tool mark identification. It was a stunning act of judicial activism that, in my opinion, is fueled by an ideological contagion that has plagued our criminal justice system for decades now, and I will explain what I mean by that in a moment. Now, what's interesting about the Adams ruling is that the appellate court is really busy. It does not have the time to conduct full reviews of entire occupations that have been around for 125 years. And it doesn't have the expertise, the resources, or the authority to convict an entire profession in a single ruling. So what does that tell us? Well, it tells us that someone else was probably doing the heavy lifting for them behind the scenes. Someone was feeding the appellate court, worn out, tired, and repeatedly refuted criticisms that were likely prepackaged and presented to the court for its own recycling pleasure from other entities who've made it their mission to eliminate firearm and tool mark identification from use in our criminal justice system. One of the most prolific of these courtroom activists seeking to literally destroy firearm and tool mark identification, I debated in New York City several years ago in front of about 300 journalists from major news outlets across the United States. And I can tell you that this individual was very articulate, friendly, uh, very intelligent, but completely clueless. Had no idea or understanding about the development and evolution of forensic firearm and tool mark identification, despite the fact that this individual regularly testified in court in opposition to firearm and tool mark identification. There is no way that this individual could have given even a 30-minute presentation on the history of the field, not even close. In just a moment, I am going to address this loyal band of courtroom science activists out there who make their rounds and, from reports I've heard, make tremendous amounts of money masquerading as experts who seem to fancy themselves as being qualified to speak authoritatively on the subject of firearm and tool mark identification, when in fact they are nothing more than commentators. Yes, they are persuasive. Yes, they are highly credentialed in their own right. Yes, they are articulate and impressive. But guess what? Structural engineers are pretty impressive. But structural engineers aren't paid as consultants in medical malpractice cases. They aren't qualified. More on that in just a moment. What I'd like to do is clear up for our purposes here a few distortions that seem to fuel these horrendous judicial rulings, such as the one we saw from Oregon. The first is the nature and definition of science itself. The argument that a practice area claiming to have scientific underpinnings is entirely illegitimate unless something is quantitatively or instrumentally measured is so far afield from the truth as to be quite embarrassing to those who perpetuate that myth. And I will go one step further. Those who claim that subjective, expert interpretations based on direct experience, education, skill, knowledge, and training are somehow inherently unscientific or invalid have actually revealed to the world that they do not know what science is. True science can be quantitative in nature, qualitative in nature, or a combination of the two. Subjectivity is a perfectly legitimate aspect of honorable and reliable areas of scientific practice. Yes, the identification of bullets and cartridge cases as coming from a specific firearm does require subjective interpretation, and that's good because we can see these marks with our own eyes. We don't need instruments to do the work for us other than a comparison microscope or to produce data for us that then gets interpreted. As I've said before, if DNA analysts could see and compare DNA strands through a microscope with their own eyes, they would sign up for that all day long. But they can't, so they have instruments that do that for them. Subjectivity, however, is not a disqualifier. Never has been, never will be, especially when it's been done for 125 years. And there's a community of highly trained practitioners that have mostly acted as responsible stewards of the enterprise. Now, does a 125-year history guarantee that testimony in a particular case happening today won't be flawed or erroneous in some way? Of course not. We're human beings. But if you're an appellate court and you've taken it upon yourself to engage in this blatant overreach and decide whether or not an entire professional enterprise is legitimate or not, you better have compelling reasons to do so. And those reasons have to be based on science, not not activism masquerading as science. But every single time, it has been the practice of firearm and tool mark identification that shows its credibility, not the critics, not the commentators, not the courtroom science activists who I believe have little regard for the seriousness of the courtroom and the interests of the parties at trial. I think they get off on their manipulation of the justice system. It's all about them and their entirely undeserved sense of scientific superiority. The second thing we need to address is the Daubert ruling from 1993, and I hope you forensic experts out there like me find this helpful. 1993 was my first year working in a forensic science laboratory, and I remember that the Daubert ruling was like a nuclear bomb going off. I mean, seriously, the defense bar jumped all over it, and they used the ruling as a platform from which to attack common forensic methods like those in firearm and tool mark identification. However, the mistake that defense lawyers made and continue to make is to think of Daubert as a standard. It is not. There is no such thing as a Daubert standard, and let me explain why. What the Supreme Court was doing in Daubert was actually fairly straightforward. Daubert was a reminder to the federal courts that they had to stop using the Frye ruling from 1923, which is often called the general acceptance standard. Frye doesn't matter like it used to, and the reason for that is the federal rules of evidence that were passed into law in 1975. And Rule 702 specifically sets forth the criteria for allowing opinion testimony from expert witnesses. That's all Daubert really does. It says forget Frye and refer to the rules of evidence. However, this is where the confusion and abuse, if you will, come into play. The Daubert court was sympathetic to judges who have the unenviable responsibility of acting as gatekeepers, as the Daubert court stated, which means that judges decide if expert testimony is to be admitted or not. And because the Daubert court recognized that judges are lawyers, they are not forensic experts, they're not engineers, they're not doctors or anything like that, it might be helpful to provide some guidance in applying the rules of evidence when considering the admissibility of expert testimony. And so the Daubert court came up with 5 guidelines that judges can consider. As I mentioned in episode 94, can the theory or practice be tested? Are there rules or standards governing its practice? Is there a known rate of error? Is there peer review and publication? And is there general acceptance within a relevant scientific community? Now, when I say that there is no such thing as a Daubert standard, it is because these were guidelines meant to help judges make difficult evidentiary determinations when it comes to expert testimony. These were not requirements and were never intended to be interpreted as such. They were suggestions for judges to consider. But the defense bar, as it often does, bless their hearts, got a little too zealous and a bit too excited about Daubert. And when they saw the court's reference to error rates, they knew that error rates, having any robust scientific foundation, just did not exist in forensic science. And so they more or less weaponized the Daubert error rate provision against forensic experts all over the United States. And they continue to do so, as they did in the Adams case. But it's based on ignorance, unfortunately, with regards to the intent and language of the Daubert ruling. So I want to make sure that my forensic colleagues out there understand this. As far as firearm identification goes, there has been a lot of progress on error rates. And as we would expect, error rates are impressively low. And while there's still going to be a lot more work done in this area, it's not even necessary to have a known rate of error under Daubert unless you buy into the mischaracterizations. As far as for the other four prongs of Daubert, all the other boxes are easily checked without question. So where does that put us? Well, from a scientific standpoint, if we understand what science really is and what it's all about, and if we understand what the underlying intent and language of Daubert is, and if we understand the federal rules of evidence and the many state rules out there that mimic or copy the federal rules, then there is absolutely no credible reason to exclude firearm and tool mark identification unless there is a specific concern about the actual evidence or testimony in a particular case being heard in a particular courtroom by a particular judge. So, what that leaves us with are critical commentaries or reports by individuals or organizations that are perceived as being authoritative, who make what appear to be credible, official, or compelling statements that a forensic methodology like firearm and tool mark identification is poorly researched or has weak scientific underpinnings, is unreliable, is invalid, needs much more research, or worse, is so bad and so unreliable that there's a strong likelihood that it actually causes the conviction of innocent people at scale. What we need to know here is that there are three primary authorities that have been widely and inappropriately recognized as being credible in their criticisms or outright rejections of disciplines like firearm and tool mark identification. And there is that roaming band of courtroom science activists, those credentialed professionals who make their rounds, get paid for their services, showing up in criminal cases to present opposing evidence that firearm and tool mark identification is not to be trusted, is not based on real science, is in need of considerable research and study before it's ready for prime time, and should therefore not be admitted as evidence. And I want to make sure that I'm crystal clear about this next point. Just as we human beings draw our life energy from the sun, these masquerading experts draw their energy from the following three authorities. The first is the 2009 report by the National Research Council, which was titled Strengthening Forensic Science in the United States, A Path Forward. This report was cited by the Oregon Appellate Court. I testified before the committee that produced this report, and my old college professor, Jay Siegel, talked on more than one occasion about how that committee and its mission had been hijacked by criminal justice reform activists, how there were too few scientists with actual forensic science experience on the committee, and how there was little about the committee that was actually objective. And although Jay often voiced pretty strong displeasure with how poorly some of the forensic experts performed when testifying before the committee, which is another problem in itself, it was not an objective, thorough examination of forensic science in the United States. And so that report simply cannot be regarded as an authoritative source by which to discredit forensic methods such as firearm and tool mark identification. The second is the 2016 PCAST report. This was a report to the President of the United States on, quote, forensic science in criminal courts, ensuring the scientific validity of feature comparison methods, end quote. The report looked like something written by people who had never stepped foot in a forensic science laboratory, and most of them probably hadn't, but I don't know that for sure. It was a horrible piece of work that was filled with inaccuracies and scientific information that was taken wildly out of context. The co-chair of PCAST, and I'm not going to mention his name so that I can remain consistent in my goal to not personalize things here, was a member of the Innocence Project's board of directors. The Innocence Project is an activist group, and a darn good one. As we're going to discuss next, its public policy mission is criminal justice reform. It is not a scientific organization. That same individual, the co-chair, according to reports, went on to become the director of the White House Office of Science and Technology Policy, as well as a key presidential science advisor, but he resigned in disgrace, according to multiple reports, after staff members reportedly went public with complaints that he created an atmosphere of intimidation through flagrant verbal abuse. And that's a quote. No court or judge in the United States should be citing the PCAST report as a credible, trustworthy scientific publication unless they are looking to embarrass themselves. That brings us to the third and final authority, which is the most important because it gave rise to the previous two. And that is the network of post-conviction criminal justice reform activists, often known as the Innocence Movement. This includes lawyers, law school students, college professors, journalists, and even scientists who believe strongly in the Innocence Movement and its mission. These innocence activists are politically, legislatively, and publicly very powerful, and for a good reason. And that is because they've been successful in overturning the convictions of innocent people since 1989. They have sent erroneously imprisoned people home to their families. And that is about as much authority as you could ever hope for if you're trying to draw attention to your work and your agenda. They are freedom fighters. And they've probably had the most profound and impactful influence on our criminal justice system, quite possibly in history. Their goal is an honorable one, which is to find people in prison who have a credible case for innocence, represent them, make their plight known to the public so that they can put pressure on prosecutors and the courts to reconsider the original convictions, which is no small task, secure their release, and then advocate for public policy reforms that will supposedly eliminate the causes of these erroneous convictions. And so every exoneree is not just portrayed as a heartwarming story of newfound freedom. Each one draws attention and money to the entire innocence movement and keeps it afloat. I'd like to ask you a question here. And think about this because it's an important one. Do you think the innocence movement would be able to attract money from donors, get front page headlines in major newspapers, and be successful in getting votes for criminal justice reform legislation if they were not producing exonerations? Is there even a need for such a large and an active political movement if there are no or very few wrongs to be righted? The answer is probably not. And according to leaders and thinkers in the Innocence Network who I've known and interacted with, they knew this problem was going to come and that it was going to be one of their biggest challenges. So when and why did the Innocence movement become so powerful? Well, excuse me, in April of 2007, the Innocence Project in Manhattan, the flagship of the movement, published a report titled 200 Exonerated, Too Many Wrongfully Convicted. It was a summary of the first 200 exonerations that were secured using DNA evidence, which was the primary focus of the Innocence Project in its earlier years. And this 200 report provided data collected and reported by the Innocence Project that explained, each case and what they argued were the most common causes of erroneous convictions, at least at the time. And what they claimed was that invalid or junk forensic evidence, however you want to characterize it, was the second leading cause of erroneous convictions, which is not even close to being true. And this fell right behind false eyewitness identifications. The report went absolutely viral. It was like a contagion. It spread through newsrooms of major newspapers all across the United States. It spread through the US Capitol and state capitals. It became the foundation of new legislation and new reports about how flawed our criminal justice system is. And perhaps most importantly, it drew what I would personally describe as an army of opportunistic supporters who themselves wanted to become a part of something special. They wanted to be a part of this movement, a part of history, a part of creating freedom for those who were unjustly imprisoned. And those opportunistic supporters included individuals with pretty impressive academic and scientific credentials who became standard bearers for the innocence movement in actual criminal cases, some often testifying as expert witnesses. But then they ran into some big problems. Well, not just big problems, actually catastrophic problems. The first was that the 200 report was full of inaccuracies, exaggerations, and data that were not presented or analyzed by professional researchers who followed professional research standards. It was a report created by justice reform activists, yet it took on the appearance of having scientific credibility, which allowed the innocence movement to then attract the support of journalists all over the world. My colleague Jay Jarvis and I authored two articles that, if you don't mind the characterization, blew the lid off the 200 report and demonstrated conclusively that the innocence movement was spewing horribly flawed and incomplete data in trying to advance its public policy campaign. It was never their goal to be accurate. It was their goal to be compelling. Our first article was titled The Wrongful Conviction of Forensic Science, and the second was Contextual Contamination by Post-Conviction, Contextual Contamination of Forensic Evidence by Post-Conviction Litigators. And we showed conclusively that not only is forensic science not even close to being a leading cause of erroneous convictions at scale, in our opinion, and it continues to be my opinion, that it's the leading preventer of erroneous convictions. And I will include links to those articles, but you can also get a copy of my book, Crime Lab Report, which includes both articles and discusses all of these issues in a more academic kind of presentation. As I said, I'll include a link to Crime Lab Report as well. The second problem was that the pressure in the exoneration pipeline, if you'll permit that analogy, slowed from that of a fire hose to that of a slow trickle of a leaky bathroom faucet. And here's why that happened. Many or most of the convictions that would be later overturned by innocence activists in post-conviction litigation occurred during a very difficult time in the history of our criminal justice system, which was during the late 1970s and 1980s. During this time, the crack cocaine epidemic in American cities was exploding and was causing historically high levels of crime that seemed to occur almost overnight. It overwhelmed our police agencies. It overwhelmed our prosecutor and public defender offices. It overwhelmed our courts and our forensic science laboratories. You could say that our criminal justice system became relegated to an assembly line. just shuffling defendants and their cases through the system like cattle. And during this time, forensic DNA profiling had yet to be invented. And so we didn't have the ability that we have now to solve cases by identifying conclusively the contributors of biological evidence, like blood and semen and hairs and other tissues. And so I don't think it should surprise us that this overwhelmed, overworked, and underfunded justice system was throwing an alarming number of innocent people into prison. I mean, look, back during this time, as I've written about previously, if if our criminal justice system had a 99.99% accuracy rate, that would still leave enough injustices to keep innocence activists busy and give them heart-wrenching stories to tell about how broken our system of justice is. With a 99.99% accuracy rate, if that was the case. And many of the overturned convictions from the 1970s, 1980s, and early 1990s were sexual assaults, which is already a very difficult kind of crime to investigate, especially when the system is overwhelmed and you don't have DNA evidence to prove who was or was not the perpetrator. It was an absolute mess and a very difficult time for our justice system. But then these cases dried up. DNA came along and had a profound impact on our ability to solve crimes using biological evidence. The crime surge ended, and these activists were stuck with these innocence clinics or innocence projects all over the United States that now weren't as relevant as they used to be. They just didn't have as many cases to justify their existence. So, in order to keep their supporters and their donors engaged, they couldn't rely strictly on new exonerations to keep up the excitement. What they had to do was pound their drum about how unfair our criminal justice system is, point to past exonerations as proof of an unfair system, and then wage a war to rid the system of the dysfunctions that supposedly cause these erroneous convictions. So another way of saying that is that innocence activists went from a corrective orientation to a preventive orientation. So this brings us full circle back to forensic science. The final catastrophic problem confronting innocence activists was that the television dramas of the late 1990s and early to mid 2000s created an unbelievably strong buzz around forensic science. Forensic science was in vogue. It was popular. It was entertaining, but it was also very good reason for citizens to have some confidence in their criminal justice system. But think about that. Think about that. If you are an innocence activist and you are trying to deflate confidence in our criminal justice system, this is a big problem that you cannot tolerate. You cannot allow the popularity of forensic science and the knowledge the public has about the good that forensic scientists do for the cause of justice to distract from your portrayal of the system as being broken. And so forensic science became enemy number one to the innocence movement and continues to be in many innocence circles. And many have paid a dear price for that. Unfortunately, there has been no shortage of highly credentialed and energetic commentators having no training, education, or practice experience in firearm and tool mark identification who are very loyal and sympathetic to the innocence movement, which is totally fine, but who've created a cottage industry for themselves, positioning themselves as prophets of sorts, weaponizing the innocence agenda, and all of its many distortions to attack legitimate science-based enterprises. And they are remarkably effective at seeming to draw from scientific wells of knowledge to discredit what they want the courts to believe are junk scientific endeavors. Well, I have news for these folks. There is no such thing as junk science. It's either scientific or it's not. You can certainly have faulty or erroneous applications of good science, and we have to respect the danger of that, which is why I'm never offended by specific forensic testimony from being subjected to rigorous scrutiny. But there's also a human side of this matter that we're discussing that we should take into account when we think about this ongoing battle of activists versus forensic experts. I want to draw your attention to a case that is described in the National Registry of Exonerations, which is the primary data center of the Innocence Network. On the evening of June 19, 1956, a store merchant in Jefferson, Georgia, was shot and killed. This was before the days of credit cards, and the victim was known to carry large quantities of cash, and so robbery was believed to be the motive. An eyewitness falsely identified a man named James Fulton Foster as the killer. Foster did have a criminal record of his own, which included robbery. He was known by the police, and they immediately suspected that he was the killer. Foster was tried and sentenced to death. But right before the execution was to be carried out, and I mean right before, local supporters of Foster had raised money for his appeal and tried to draw attention to what they believed was Foster's innocence. This led to a man who was already in prison who confessed to the murder. He signed an affidavit confirming that he was indeed the killer, and so James Fulton Foster was released with almost no time to spare. He was literally hours from being executed. Now, when you read about the Foster case in the National Registry of Exonerations, a rather important bit of information seems to have been curiously and conveniently omitted from the case summary. And that is that a firearm and toolmark examiner was able to conclusively identify the firearm that was used to kill the store merchant. And this identification confirmed the confession of the man in prison who came forward and allowed Foster to escape death. Now, earlier I mentioned my desire to take issue with these masquerading courtroom science activists, and I'm really doing my best not to call these people out by name. These so-called experts who have anointed themselves as the scientific prophets who are trying to relieve our criminal justice system from this supposed junk science that they have such a problem with. But they know who they are, and they have questions to answer, tough questions, and I can't help but wonder if they would be willing to argue publicly that the execution of James Fulton Foster should have gone forward, that an innocent man be put to death. Was Foster not worthy of having his innocence revealed because it was a firearm and toolmark it was a firearm identification that confirmed it? And by the way, I'm not surprised that the National Registry of Exonerations fails to mention the firearm identification, because that would run counter to the innocence agenda. The innocence agenda will not allow a forensic method like firearm identification to receive good press or to be credited with saving a man's life, which I thought was what the innocence agenda was about. This is why you have to be so very careful when considering the data or interpretations of activists. This was an irresponsible omission of relevant information. Yet when you look at the registry's other case summaries, they go into striking detail about the evidence and the investigations, but no mention of the firearm identification that saved the life of an innocent man, James Fulton Foster. You know, many years ago, I was I was leaving a courtroom after testifying about my identification of a firearm in a shooting death. This was probably around I don't know, 1995, 1996, something like that. And as I was leaving the courtroom, the mother and sister of the victim followed me out of the courtroom and gave me a big hug and said, "Thank you so much. Thank you for helping us figure out who killed my son, my brother. Thank you from the bottom of our hearts." And all I could do was say, "You're welcome." And I'm so sorry that you lost your son and your brother. I wish I could bring him back, but all I could do was just help figure out who killed him, which they understood. And I'll come back to those ladies in just a second, but I want to use some more well-known examples to make a point here. For example, I doubt that the band of courtroom science activists out there would be willing to state publicly that, you know, we can't say that Lee Harvey Oswald's rifle killed President Kennedy, or that we really didn't solve the horrific DC sniper case that terrified the entire community back in 2002. And I doubt these science activists would ever step in the way of investigators trying to show what firearm was used in a school massacre, such as the one at Sandy Hook in Connecticut. They wouldn't do that because everyone would think they were crazy, and they know it. So why should that mother and sister who hugged me deserve anything less? Based on what we've talked about today, what rational or scientific reason, one that has even an ounce of logic behind it, would justify denying the family of a murder victim from knowing what gun was used to kill their loved one, when a qualified firearm and toolmark examiner may have 125 years of compiled data, publication, and practice that allows that question to be answered? Tell me, please. To you courtroom science activists out there, what on earth could possibly motivate you to deprive everyone involved in a criminal case of the opportunity to know one of the most important facts in the case, which is what gun fired what bullets or cartridge cases? Who the heck do you people think you are? You need to stop this now. Please stop manipulating our courts by making your activism look like science. I understand that you're credentialed. I understand that you may have held lofty positions, and I respect you for that. I understand that there is money to be made. I understand that you might feel loyalty to the innocence movement, and perhaps it makes you feel good about yourselves to be celebrated as heroes among your fellow innocent soldiers who are hanging on for dear life to stay relevant and influential. As I've said here, I have no problem with scrutinizing forensic evidence in specific cases because I know humans can make mistakes. And there is always the possibility of error in any human endeavor, including forensic science, including medicine, including engineering and accounting and even lawyering and even activism. But for a group of professionals, and I use that term hesitantly, professionals having no independent experience or training in the practice of firearm and toolmark identification, which has enjoyed more than 125 years of success, for you to think it's appropriate and justifiable to to openly dismiss or reject this entire category of forensic evidence, one that's been practiced and scrutinized and researched to a significant degree, rises to a level of irresponsibility, carelessness, arrogance, or dare I say, in the worst instances, sociopathy, which I hope is not the case, but it just might be. The confusion you are willing to create in serious matters where people have sometimes lost their lives and grieving survivors are praying for answers, I'm I'm just going to leave it up to my listeners and viewers to decide what they think of people like you. I know what I think. You know, I had Sarah Chu on the show some time ago. I believe that was episode number 85. I remember it well, but the reason I admire Sarah and respect the work she does as an advocate for the innocence movement is because she has a genuine professional desire to see the entire justice system be more competent in how it uses scientific evidence. She encourages and enables better practice. She's not out there as a hack trying to deprive the justice system of legitimate evidence. She just wants it used as responsibly as possible. So I would put Sarah out there, and I hope she doesn't mind me saying this, as an example of what it looks like to be a responsible and thoughtful advocate of the innocence movement. And it makes me proud to have her as a friend and a colleague. And I do want to add something here. I want to express my my disappointment in some of our more influential forensic science leaders and organizations over the years who were and are supposed to advocate for the use of forensic science in our justice system, who have given a safe haven to these characters and have failed to show the leadership and courage needed to put a stop to what is clearly unacceptable professional behavior. I once confronted, politely so, in an open forum, the president of the American Academy of Forensic Sciences. This was many years ago. And I asked him why the Academy gave a platform to these activists and why did it not stand up to provide support to legitimate forensic science professionals who were being unfairly marginalized and mischaracterized by the criminal justice reform movement. This was in a public open discussion forum. And you know what he said? He said there's value in the criticisms because we can take advantage of it to attract money and attention to ourselves and our profession. This was the president of the American Academy of Forensic Sciences. No apparent concern or regard for the thousands of forensic scientists out there working their tails off, whose reputations and ability to do their jobs are being undercut, oftentimes without good cause. Yes, there are bad apples, and there have been bad apples in the past who deserved the scorn they got, but by and large, too many good, honest forensic science professionals have suffered unfairly because of the unbridled activism that has just run roughshod over our criminal justice system for decades. And what I came to realize as plain as day is that these attacks are often enabled by individuals inside the forensic science community who are either afraid of justice reform activists and want to appease them or genuinely support what they do. And it's probably often a combination of the two. And that's okay as long as we don't allow our social or political goals to encroach on our scientific and ethical responsibilities. But it seems that when it comes to criminal justice reform activism, all caution and professional self-restraint seems to get thrown out the window. And that's really a shame. And it hurts the credibility of the movement itself, which hurts any innocent people in prison who will depend on that credibility when the moment requires it. For those of you in the firearm and toolmark community, and for the many others who help our criminal justice system leverage the power of stochastic patterns. I know you don't need me to come to your rescue. Um, I think that the work that you do and the organizations that support you are honorable and responsible and worthy of our respect. But I do have something that I want to say to you. Please be proud of what you do. Do it well, do it with professionalism and class and competence and with an eye toward continued scientific advancement. No high responsibility field of endeavor should ever be stagnant. So embrace the evolution of the field and be a champion for its future. You aren't going anywhere. You matter too much. If a judge or court wants to deprive a jury of the opportunity to know the truth about the evidence in a case, that's on them. It's not on you. But at the same time, you've got to know your science. You can't just say, I followed this procedure or that procedure. You also have to understand what that means or what it's based on. You have to be able to independently defend what you do under the most challenging of circumstances. Sometimes we have experts who fall short in that responsibility, but at the same time, some of that responsibility is on direct counsel. Never assume the court knows why your work has scientific merit, and be very wary of prosecutors who take for granted that the court will just recognize and accept your testimony without question. That would be disrespectful to the court. So avoid the mistake of not adequately laying the scientific foundations of what you do, because after all, it's been around for a century. Well, yeah, those 125 years, that might matter in the grand scheme of things, but not necessarily in this case with this particular evidence. You have to be a competent and consummate champion for the evidence and the science that makes sense of it. That's not the job of prosecutors, defenders, and it's not the job of the judge either. It's up to you. It's up to us. And I hope this episode will help you going forward. And if you encounter one of these science activists showing up in your jurisdiction or in a case you've been involved with, look at it as an opportunity to tell the truth about your work, your science, and your credibility as a firearm and toolmark examiner. And if you feel that you need some help, don't hesitate to reach out to your colleagues and mentors or even me if you think I can help you. So let's take a moment to quickly summarize what we've done here today. We've brought clarity to the definition of science. We've explained the truth about the Daubert ruling of 1993. We've also added some context to the 2009 National Research Council report and the 2016 PCAST report, although I suspect I may be doing another episode on those reports in the near future. We'll see about that. That would be interesting to do. But the reality is that they are not scientific documents having scientific weight. They never were, they never will be. They are policy documents that were heavily influenced by criminal justice reform activists who were mistaken for scientific experts. So I hope that perhaps this activism makes more sense now as we've explained some history related to the innocence movement and why it can't be trusted as a source of scientific truth, although we can and should be grateful for the work that innocence activists have done, as I know I am, to right wrongs and to create hope for prisoners who actually may have a credible case for innocence. I'm glad they're around, and I'm glad they do what they do for us. But their obsession with invalidating across the board some of the most well-tested and most successful forensic methods has to stop. They are hurting their own credibility, and they are hurting our courts. And finally, to you courtroom science activists out there making the rounds, I personally feel a newfound inspiration to pay close attention to what you're doing. And I hope others will feel the same inspiration to keep an eye on you and minimize the damage you're doing. I'm going to create a printable transcript of this episode, and I hope that it will empower forensic experts and other criminal justice professionals to subject you and your opinions to the scrutiny they deserve. And we'll see where that leads us. So for now, consider yourselves on notice. I'm John Collins. Thank you so much for joining me for another edition of Crime in the Courtroom. Please email me directly at john@criticalvictories.com with any questions, comments, or feedback about this important episode. I will see you next time. Thanks again.